applications and appeal in the matter of Her Royal Highness the Duchess of Sussex and Associated Newspapers Ltd.
Lord, my lady.
Good morning, Mr. Caldecott.
Lord, on this appeal I appear defendant, Associated Newspapers, with Mr. Adrian Speck, Queen's Counsel, Alex Marzek, Isabel Jamal, and Gervase de Wilde. Mr. Rushbrook and Mr. Mill, Queen's Counsel, and Jane Phillips and Jessie Bowhill appear for the claimant, the Duchess of Sussex. And Lord, there's a division of tasks on both sides, and I have to say in my case a division of expertise, in that I will address the privacy issues and Mr. Speck the copyright issues. That is how it was done below and how it will be done here. And for the respondent, the division of labour is Mr. Rushbrook on privacy and Mr. Mill on copyright. As the court will know, the appeal is against a summary judgment entered by Mr. Justice Warby, as he then was, on the 12th of May.
Just before you go on, Mr. Caldecott, can I just raise a couple of things? I think you know, you don't have to sit down. I think you know we've allocated 2.5 days now. We'll be sitting until 1 o'clock today and then all court day tomorrow and Thursday. There is no wriggle room, I'm afraid, in those sittings, so you must agree the division of submission time. Secondly, we're prepared to make the order on publicity that you have agreed to the effect that the order of Mr. Justice Warby is varied to allow reporting of this hearing. And thirdly, as everybody knows, the hearing will be live streamed in accordance with the Court of Appeal's usual practice. I understand there is no formal transcript being prepared which we will have access to, which means that all counsel must take that into account when making their submissions, because that makes it slightly more difficult for us to proceed quickly, but that is your choice. So those were the points I wanted to make, and then you proceed with your submissions. How long do you expect to be on your side?
Lord, we are hoping to do it within a day or very slightly over a day, but I shall try to do it in a day, to leave ample time for reply.
Right.
And that would lead to a reasonably equal division of time in terms of principal submissions. I may go slightly over with Mr. Speck as a joint enterprise. We may go slightly over, but I'll aim not to. I'm afraid it's always difficult to know what questions one might be asked, and this is a fairly layered appeal.
Okay.
Lord, just one thing. I'm aware that my Lord the Master of the Rolls is looking at this virtually, or has been.
I don't use paper. I've just been given some, but
yes.
I'll look at that because I can see the layout nicely on it.
Yes.
Otherwise, everything has to be sent electronically to me, I'm afraid.
No, my Lord, not at all. I raised the point because I'm aware of it, and I hope the references won't cause a problem. As your Lordship knows, virtual references and hard copy references...
Well, in this case, they haven't been done properly, Mr. Caldecott.
Well, my Lord, in that case, that's an apology at the outset. But Lord, I'll do my best. If there's any issue, Mr. Gervase is going to follow the virtual references.
I'm pretty good at keeping up.
Yeah, thank you, Lord. Lord, as the court will know, the judge's principal order granting relief is at Core Bundle 1 at tab 10. Paragraph 2 grants an injunction in wide terms. Paragraph 3, an account of profits in copyright. And paragraph 5, so we have that in mind, is worth bearing in mind that the judge made no order on the other application which was before him, which was a strikeout application. A further order for relief was made on the 5th of May, which is at tab 16, and the court will see from paragraphs 3 and 4 that there's a delivery up order in paragraph 3 and again in paragraph 4, that was made in the copyright action. Permission to appeal was granted by my Lord Justice Bean on 8 of the 12 grounds of appeal on the 22nd of June, and his order is at tab 18 of Core Bundle 1, and the court will have noted that there are 4 grounds of appeal which were refused, and I'll say no more about them, but just to give you the numbers, it's grounds 4, 7, 10 and 11. And in addition to the grounds of appeal, there is a respondent's notice at tab 5, which invites this court to find that the defendant has no reasonable prospect of success on various factual issues, and I'll have to come to that later. As the court also knows, there's an application from us to adduce new evidence, and the claimant's position on that is to oppose it, but if it goes in, she wishes to adduce a witness statement and some documents. The new evidence comprises a witness statement from Mr. Knauf, who was the communications secretary after the wedding until March 2019, and that is the new evidence. And the court has helpfully indicated that that has been read de bene esse, and that a view will be taken in the course of the hearing. It's
Yeah, I think really a view will be taken in our judgments, Mr. Caldecott.
Yes.
We have all argument on the new evidence that anybody wants to adduce, and we'll deal with it in our judgments in due course.
Can I just say, well, that's extremely helpful to me, because dealing with it discreetly would have been difficult. Housekeeping matter, your lordship's already spotted the large article. Can I just say that's there mainly for legibility, because the one in the bundle is the hard copy of the articles complained of. The bluing represents the material which is complained of in privacy, and we've just added some paragraphs so everybody can refer to it more conveniently. And that's the only, it's already in the bundle, but in a less approachable form. There are also 2 draft pleadings which reflect the new evidence and make some deletions which I will introduce as I get to the relevant stage in the facts. And well, can I give your lordship a very brief roadmap of how I'm going to approach the case? Mm-hmm. Firstly, a very short, neutral account of the background, so anyone watching this hearing can understand what it's broadly about. Secondly, an equally short, but no doubt contentious summary of our reasons for submitting that we did have, or do have at least, a defence with a realistic prospect of success. Thirdly, submissions on the law, and I will try to indicate what I believe is common ground and where the more disputed areas are. Fourthly, submissions on the facts, bearing in mind that it is well settled that in this area an intense focus is required on the facts, and a mere recourse to generalities will not do. It's also relevant to identify what was before the judge and what the potential new evidence in this court shows. Then I'm going to come to submissions on the judgment, and then lastly, brief submissions on due diligence and the fresh evidence, insofar as I haven't dealt with them already. So first of all, if I may, to the neutral proceed. The Duke and Duchess were married on the 19th of May 2018. The Duchess's father, Mr. Thomas Markle, did not attend the wedding. I'm not quite sure whether he was 73 or 74 at the time, but he was born in 1944, so he was one or other of those 2 ages. And for obvious reasons, his absence attracted considerable speculation. Earlier, on the 13th of May 2018, a story about his dealings with paparazzi appeared in the Mail on Sunday. Mr. Markle apologised to the Duke and Duchess for his conduct in this respect in a text the 14th of May, and his apology was accepted. At about this time, Mr. Markle was suffering heart problems. He told a celebrity website, TMZ, on or about Monday the 14th of May that for health reasons he would not make the wedding, and he texted the Duke and Duchess to inform them of this on both the 15th and the 16th of May. As I say, the wedding was on Saturday the 19th. He had a heart procedure on the 16th of May and was advised by his doctors not to fly. The text messages passing between the Duchess, Prince Harry and her father at this time were before the judge and require close scrutiny. Mr. Markle has never met Prince Harry. In the summer after the wedding, Mr. Markle gave an interview to Good Morning Britain on the 18th of June 2018 and another on the 28th of July 2018 to Mail Online. The judge summarises them at paragraph 42 of his judgment. The Mail described those interviews as damaging, as observed by the judge in the following paragraph. On the 27th of August 2018, the Duchess sent her father a letter. It contained an account of the pre-wedding exchanges, rebuked him for talking to the media in strong terms, and asked him to desist from doing so in the future. It did not contain any attempt at reconciliation. The Duchess had not, in fact, attempted contact with her father since the wedding, apart from this letter. Mr. Markle replied to that letter in September 2018.
Don't know the precise date?
We don't, Lord, no. No, I'll just confirm that. It included a passage which is set out at paragraph 46 of the judge's judgment, which I'll have to refer to, but which the court is no doubt aware of, concerning a suggestion that a photograph be given to the media and that might put matters or enable their relationship, as it were, to be restored. He didn't share the Duchess's letter to him or his reply to her with the media at this time, nor did he publicly refer to their existence. On the 6th of February 2019, an article appeared in People magazine, headed "The Truth About Meghan," and based on interviews with 5 of her friends. The article or its gist were reported worldwide. The Duchess's letter was deployed as if it were an olive branch from a caring daughter, and Mr. Markle's reply was presented as wholly inappropriate. Neither the text of the claimant's letter nor any text from Mr. Markle's reply were included. The article contained other serious allegations against Mr. Markle in relation to his dealings with his daughter and Prince Harry, including in the pre-wedding period. It also portrayed the claimant as a caring daughter throughout. Mr. Markle considered the article to be a serious attack on him, unfair, and a travesty of what had actually happened, and he decided to reply. He gave the letter to the Mail, who published substantial extracts from the letter in 2 double-page hard copy articles on the 10th of February 2019, that is 4 days after the People article first appeared, accompanied by commentary and further background. 3 online articles followed. The claimant brought proceedings for infringement of privacy and breach of copyright on the 29th of September. When the judge decided to give summary judgment, there were voluminous statements of case, but no disclosure. A schedule of the pre-wedding texts, and by that I mean in the relatively short period up to the wedding, were attached to the re-amended reply, so they were before the judge. Now, to assist And just to provide a little context for the law to which I'm coming to almost immediately, can I just give the court a more contentious summary which reflects our stance on this appeal? If the court would like it, I'm very happy to hand these points in both in hard copy and a virtual copy of the Master of the Rolls, if it's thought helpful, but let me read it first.
Well, you can definitely hand it in any form you like, but for me, virtually, please.
Lord, yes, thank you.
Electronically.
Well, Lord, the first point we make is this: we read the judgment as implicitly accepting that the letter was crafted as an intimate communication for her father's eyes only. That is how the claimant's case was put before the judge, both in writing and orally. That fundamental point turns out to be false on the new evidence. The letter was crafted specifically with the possibility of public consumption in mind, because the claimant appreciated Mr. Markle might disclose it to the media. That nuanced position was not before the judge. Secondly, the claimant's letter and the People article both make allegations against Mr. Markle of cruelly cold-shouldering the claimant in the pre-wedding period, which are demonstrably false or misleading in the light of the contemporaneous text messages which were before the judge. We challenge the judge's legal reasons for dismissing that case, and we also challenge his factual analysis. Thirdly, the People article suggested that Mr. Markle had lied in alleging that the claimant had shut him out after the wedding. The article also describes the claimant as always taking care of her father with, and I quote, incredible generosity. The claimant admits that she had in fact not contacted her father other than through the letter since the wedding. The People article portrayed the letter as an olive branch when it was no such thing, as the judge found and the claimant accepted. It is not and was not contended before the judge that the defendant did not have an arguable case that the People article came directly or indirectly from the claimant. The claimant made no effort to correct the People article after publication. 4. The People article also referred to Mr. Markle's letter of reply to the claimant's letter and portrayed it as wholly inappropriate and cynical in suggesting a photo opportunity. We say there is a difference between what Mr. Markle actually said and what he was presented as saying, and in any event an arguable difference sufficient to engage his right of reply in terms of both her letter and his reply. 5. These facets of the claimant's letter, Mr. Markle's letter in reply, and the People article all interact. Mr. Markle's allegedly cynical response to the alleged olive branch is made to look much worse because of the claimant's alleged good behaviour towards him and his earlier pre-wedding bad behaviour towards her. 6. There is a public interest in knowing to what extent the People article accurately reflects the tone and content of the claimant's letter in relation to what the letter says both about him and about her. The judge's approach to correction, right of reply, and the wider public interest was, we suggest, much too narrow and contrary to authority. It is true that in this area of the law, a distinction is often drawn between generality and detail. However, in this case, the detail, including the text of the claimant's letter, was necessary to a fair understanding of what was a continuing debate on a matter of public interest. The judge concluded that publishing the text of the letter was not even capable of making a contribution to such a debate and was solely to satisfy public curiosity. We challenge that conclusion as plainly wrong. 7. At or about the same time as the People article appeared, it's actually slightly earlier, the claimant cooperated with the authors of a book later entitled Finding Freedom through her communications secretary, Mr. Knauf, in autumn and winter 2018. The claimant expressly denied any such cooperation in her pleaded case, with one minor exception, and that is now, we say, contradicted by the evidence of Mr. Knauf. Self-evidently, that material was not before the judge. 8thly, the claimant does admit in her pleaded case communication with the authors of the book about her relationship with her father and the letter via a friend. We don't presently know who the friend is, and we say that the pleaded case as to precisely what that information was is to some degree opaque, and I'll show the pleading in due course. 9. The book was not published until early August 2020, long after the articles complained of, but it substantially reproduces the claimant's case as set out in the letter and the People article about her father's bad behaviour prior to the wedding, and it is generally very favourable to the claimant. The defendant does not allege that a copy of the letter was given to the authors, and indeed it doesn't know either way. 10. Against this background, the defendant submits it has a strongly arguable case that by the time of publication of the articles, the claimant no longer had a reasonable expectation of privacy in the text of the letter, bearing in mind, among other things, that it was written with public consumption in mind as at least a possibility, or if she did, such a right has been diminished and is outweighed by Mr. Markle's right of reply, the need for correction, and the wider public interest. Those three concepts all being distinct and all engaged. Lastly, the claimant's pleaded case can be shown to be materially false in important respects by reference to the contemporaneous documents. Subject to one very limited admission, the claimant denied any cooperation with the authors of the book. She also denied that she ever even suspected that Mr. Markle might leak the letter, and that it was therefore written as an entirely private document. We say this raises questions about her credibility and also provides with other material a reasonable ground for believing that further relevant material may emerge in the course of disclosure which could affect the outcome. Law.
Now, you're going to let us have a written version of what you've just read out far too fast for us to actually
Lord, I'm sorry.
record.
Yes.
I mean, that to a large extent encapsulates your submissions. It would help me, because I find, quite frankly, your grounds of appeal diffuse and unfocused, if you were to say precisely, presumably you're going to, what you say was wrong with the judge's decision, A at stage 1, B at stage 2, and C on the balance between Article 8 and Article 10.
Lord, yes. That's obviously central.
And I would like that very clearly stated, Mr. Calden,
Lord, yes.
so that I understand what your case is how you say the judge's judgment was wrong in law. I understand the factual criticisms that I suspect you'll make good at probably significant length, but I'm, in the first instance, interested in where the judge you say went wrong in law.
Lord, absolutely, I understand that. And when I go through the law, I will, from time to time, go to the judgment to answer your Lordship's question, I hope.
I think it should be capable of 3 or 4 paragraphs of summary.
Yes.
Which we find nowhere because of the detail which obfuscates focus.
Yes. Well, Lord, I hope I'll provide some focus as I go through these different legal principles, and as I come to each one, I'll refer to the judgment where they're contentious, because it won't be surprising to know that a judge of this experience, some of it is undoubtedly correct. Lord, can I just, I'm not going to take up the court's time with principles which are obviously common ground and well known to the court. First of all, the broad legal principles governing summary judgment are clear. They're set out in the judgment at paragraphs 10 to 16. And the main source is Mr. Justice Lewison's key principles in the Easy Air case. And it obviously follows from the finding of summary judgment that the judge concluded that the defendant had no realistic prospects of success and that no evidence could reasonably be expected at trial which might affect the outcome of the case. Just so your Lordship has that last point in mind, it's Roman 5 of the Easy Air list at paragraph 13 of the judgment must take into account not only the evidence actually placed before it, but also the evidence that can reasonably be expected to be available at trial. Secondly, it's common ground that this is an appeal against a very full judgment from a very experienced judge, and subject to the impact of the new evidence, the relevance of this factor is succinctly explained in paragraph 45 of Lord Brown against Associated Newspapers at Authorities Bundle 2, tab 31, and I can read this, it's very short, but it's well known. At paragraph
Tab 24.
Oh, sorry, 24. Did I say 42? Right.
You said paragraph 45, is that right?
Yes, I did.
Correct approach on appeal.
It is, Lord, it is. That is the right paragraph, sorry. The approach which should be adopted on an appeal of this kind is not, we think, in dispute. Although the exercise upon which the judge was engaged was not the exercise of a discretion, it was similar and it involved carrying out a balancing exercise upon which different judges could properly reach different conclusions. In these circumstances, it's now well settled that an appellate court should not interfere unless the judge has erred in principle or reached a conclusion which was plainly wrong, or put another way, was outside the ambit of conclusions which a judge could reasonably reach. And that, of course, underpins the question your Lordship put to me about the importance of focusing on where we say the legal errors lie. Lord, secondly, it's common ground, and your Lordship's already put it to me, that a two-stage test applies. Claimant has to establish a reasonable expectation of privacy, and that at stage 1 is a binary question, and the answer is yes or no. It's not a binary question.
Sorry, you say it's a binary question.
Well, at stage 1, it's a binary question. She either has a reasonable expectation of privacy or she does not. It becomes a more layered issue at stage 2 because one has to weigh the Article 8 right. But at stage 1, it's a binary question. She either
I
has...
don't quite understand what that means. The authorities tell us, as I understand it, from Brown, I think a couple of paragraphs back from where you've been looking, that it's an objective question,
Yes.
and that it requires the court to take into account a number of matters of factual background. So, obviously, any question is binary if it admits of answers yes or no, but does that tell you anything?
No, look, it doesn't tell us anything, save for this, that the only reason why I make the point is that at stage 2, the Article 8 right has to be weighed, and plainly in some cases it can be very strong, in other cases it can be quite weak. Stage 2 obviously only arises if stage 1 is satisfied.
So you don't conclude at stage 1 that there is an Article 8 right to privacy in this document, but it is weakened by factors A, B and C. You say there is an Article 8 right of some kind, answer yes or no, yes, and then consider whether it's weakened by factors A, B and C only at stage 2.
More precisely.
And I sort of detect some nodding on the other side. It seems to be common ground.
Lord, I think so. I don't think this is controversial.
The second question is whether the Article 8 should prevail.
Correct, and that does require you to weigh the rates. The proportionality exercise at stage 2 does require a weighing of both the factors going to the Article 10 freedom of expression side of the equation and the factors going to the weight of the Article 8 right. Lord, it might just be helpful just to look a little bit at 2 passages in Campbell, which still remains a leading case for these purposes. It's tab 18 of Authorities Bundle 1.
Well, we're bound by it.
Oh, yes. Lord, firstly, Lord Nichols at paragraph 21. Accordingly, in deciding what was the ambit of an individual's private life in particular circumstances, courts need to be on guard against using as a touchstone a test which brings into account considerations which should more properly be considered at the later stage of proportionality. That slightly echoes what I've been seeking to emphasise. Essentially, touchstone of private life is whether, in respect to the disclosed facts, the person in question has a reasonable expectation of privacy. And the other observation that the court might find helpful is Lord Hope at 99. He criticises the Court of Appeal at about 99, just below the letter G. They were also in error, in my opinion, when they were asking themselves whether disclosure would have offended the reasonable man of ordinary susceptibilities. The mind that they examined was the mind of the reader. This is wrong. It greatly reduces the level of protection that is afforded to the right of privacy. The mind that has to be examined is not that of the reader in general, but of the person who is affected by the publicity. Then this is the useful sentence. The question is what a reasonable person of ordinary sensibilities would feel if she was placed in the same position as the claimant and faced with the same publicity. Your Lordship is entirely right that it's an objective question, but nonetheless you take into account the claimant's subjective position. Just for your lordship's note,
But you go so far, as I understand it, as saying that the judge was wrong to answer the binary question, yes.
Lord, we do, but we also have a fallback position that if we're wrong about that, the right was greatly weakened by various factors that we point to.
So then the claimant would have a reasonable expectation of privacy,
Yes,
but you emphasise a, and you say, well, not much of one.
yes, precisely, Lord.
But that's a stage two.
Two, correct,
Yes.
Lord, absolutely. Can I just for your lordship's note, there's a recent decision of this court in ZXC, which we'll have to come to for one reason later, which is an authorities bundle 2 at tab 36, and at paragraphs 40 and 44 respectively, those two dicta from Campbell were treated as valuable guidance, so they're core paragraphs as to the right approach.
You didn't have any choice but to treat them.
Precisely. Yes, but Lord, it's just that those particular paragraphs are chosen as being useful.
What was the tab number for ZXC?
Lord, it's tab 36 in Authorities Bundle 2.
Yes, my lord was in the case.
Yes.
The Lord Master Rails already alluded to the Murray factors, as they're called. It's well recognised that they are a useful approach at the first stage. The only caution one has to have is that the relevance of individual factors may vary from case to case, and they're not a checklist. Can I just tell your lordships where it's to be found? It's Authorities Bundle 2, tab 25 at paragraph 36, but it's common ground, and I don't propose to go to it. Now, there is, we submit in this case, quite an important question about burden of proof. It often does not matter in cases of this kind because the nature of the information, the claimant's dealings with the information, and what the defendant disclosed are common ground and they are to see. That was certainly the position in the Campbell case. But in this case, there are real issues about the dealings with the letter, both as a generality and in detail in terms of its preparation. Now, there's only one observation that I have been able to find specific to this area of the law, and that's a case called Hutchison, and I would readily accept at the outset it's an interim relief case, so it's not quite the same as the geography of the present case. It's at tab 29 of Authorities Bundle 2. And if the court would kindly look at paragraph 31, and I emphasise this was an interim relief case. So far as the burden of proof is concerned, it is, in my judgment, unnecessary to take time over a somewhat theoretical discussion as to legal, evidentiary and shifting burdens. Suffice to say that it is for the applicant for interim relief to make out the case of an infringement of his Article 8 rights, and for the respondent to raise a case of freedom of expression under Article 10. But ultimately, in a matter such as this, it's plain that the burden rests on the applicant to satisfy the requirements of Section 12.3 or to fail. Now, Lord, this is of importance for this reason. There are a number of criticisms of our pleading for lack of particularity in relation to matters which we could not possibly know the fine detail of. For example, the details of what the claimant asked the friend to communicate to the authors of the book, or the details of what the friends told the People magazine beyond what appeared in the article. Now, we say, in order to do justice, provided the issue is broadly speaking raised, it is for the claimant to be open about any relevant dealings with the information which he seeks to protect. We also submit that there is some support for that in the rules. I hope your lordship, have you got your CPR volume 1? I'm afraid this isn't in the bundle, it probably should be.
Which rule do you want? Are you looking at the notes?
Page 1964, please. And it's CPR Practice Direction 53B. And it's headed Misuse of Private or Confidential Information at page 1964. I'm sorry it's not in the bundle, is it? Sorry, lady. You want that? Thank you very much. Sorry.
1964.
1964, please.
Can you also provide an electronic copy of this in due course?
Lord, yes.
Yeah.
You keeping the note? Lord, 8.1 at the bottom of the page, under the italicised heading, Misuse of Private or Confidential Information. In a claim for misuse of private information, the claimant must specify in the particulars of claim in a confidential schedule if necessary to preserve privacy the information to which she claims to have a reasonable expectation, the facts and matters upon which she relies in support of the contention that they had or have such a reasonable expectation. 3, use or threatened use, I needn't trouble. But then 4, any facts or matters upon which the claimant relies in support of their contention that their rights not to have the specified information used by the defendant in the way alleged outweighed or outweigh any rights of the defendant to use the information in that manner. And then the next rule, as your lordship will see, deals with breach of confidence.
When was that added?
And, that's a very good question, my lord. For this reason, this was added the day after this action was commenced. And they came into effect on the 1st of October 2019, when the Media and Communications list became a specialist list.
Which date?
Sorry, it's the 1st of October 2019.
Yeah.
And on the same date, the Media and Communications list became a specialist list, and all the privacy claims had to be heard there.
I think it had been a specialist list before that.
It had.
There had been it was a revision of
The assignment of cases to the list, yes, your ladyship is right. Sorry, I put that too simply, but that is exactly right. I stand
The
corrected,
court's
that's right.
pretty well aware of how the MAC list came into
Yes,
being and its development.
Yes.
As, court got.
can I just...
before you leave that point, Mr. Caldecott, can I just ask you how you say that would work, would or should have worked? It may be you're coming to it, and if so, you can deal with it later, but how you say this could and should have worked in the context of the application before the judge, what this actually means.
It's a rather curious position, because in the procedure which does apply to this action, having been commenced a day earlier, there is a duty to disclose early any adverse documents. I was going to come to this a bit later when I come to the documents themselves.
But I'm not sure you're right in saying that this doesn't apply to your proceedings, because did you issue the proceedings with a claim form, or did you issue the proceedings with particulars of claim? Because when you at least amended the particulars of claim, you would have had to satisfy the new practice duration.
The particulars of claim were certainly served later.
Right, so when you served the particulars of claim, presumably you were bound by the new rule.
Yeah, but the claim
They
was,
were
yes,
bound by the new
yes.
rule,
Well, Lord, I would agree, I mean, respectively, that taking a point on one day on the rules, I mean, it's the policy underlying it which I'm really seeking to address.
Yeah.
But can I come back to the ladyship's when I come to the disclosure obligations, because they are another aspect of this. But can I just answer your ladyship's question in this way? Certainly once the defence is put in, whatever view one takes about the particulars of claim, once the defence is put in and relies on such matters as the communication with the authors of the book, the communications via a friend with the People magazine, the way in which the letter was prepared, and the court will be aware, I'll have to come to this later, that there was before the judge a case on media strategy, which we have since withdrawn for reasons I'll explain. But once that is pleaded in the defence, there was an obligation on the reply, we say, to be open about these matters. And that therefore the position which the documents now show should, at least in pleading form, if not the documents, have been available to the judge when the matter was decided.
This is all, descending really into the arena of factual dispute. I'm still very, very keen, Mr. Caldecott, that we keep our eyes very firmly on what you say the judge decided that was wrong, A, in law, and B, in fact.
Yes, but it was only an answer to the ladyship's question.
But sorry, but ultimately, otherwise you don't get your, if I can put it this way, your screwdriver into the judgment.
No.
You need to show us where he went wrong.
Yes, and I haven't touched really, as your lordship will note, on the contentious areas yet.
You haven't.
Because most of this is common ground, but it's right just to inform the court of the legal position.
Can we put practice direction 53B away for the moment?
Yes, your lordship can.
Yep.
Lord, there is a reference in the grounds of appeal taking issue with the judge's comparison between breach of confidence and reasonable expectation of privacy at paragraph 91 of his judgment. I recognise this appeal is not going to turn on that criticism. I may come to it, back to it a little later, because it does go to the weight to be given to the Article 8 right, because the judge says that a reasonable expectation of privacy generally is a stronger right even than confidence. And he does add this curious phrase, which is worth bearing in mind for when I come to stage 2, and the law's objective is to protect the individual's convention right to respect for her autonomy. We accept that autonomy is undoubtedly a value, and when we go back to Campbell, we'll see that Lord Hoffman describes the right to keep your information private and to decide when to release it, and I'll come back to the importance of that. Now, can I just go to the second stage where we get to much more contentious ground? If a reasonable expectation of privacy is established, there follows a proportionality exercise in which the competing rights to privacy and freedom of expression are weighed and each right is treated as equal at the start. Now, we don't cavil, broadly speaking, with paragraph 31 of the judge's judgment, provided the rather important words or vice versa are added at the end of the first sentence. But broadly speaking, paragraph 31 is a fairly orthodox summary of the stage 2 exercise. But we do take issue with how this then develops. Can I just give some examples of this development? First of all, at paragraph 35, there is a reference there to the defendant has failed to discharge the burden which rests upon it to advance a viable justification for interfering with that right. Now, it doesn't stop there, this theme, it develops. And can I just take your lordships to a couple, there are in fact more than two, but now look at 106.
Well, that struck me as odd because Article 10.2 is about is the burden being on the person who wants to oppose freedom of speech.
Yes.
And of course, the defendant in this case is not opposing freedom of speech,
No.
but advocating.
Lord, yes, it goes further, as we'll see, because if the Lordship would kindly look at how the judge formulates the key assessment at 106, and he's dealing here with editorial latitude, but he goes on in about the 6th line to say the court will assess for itself. And you'll see that there is a reference to potential, whether there is a logical or rational connection between that potential justification and the publication complained of. But then these words, the court will also be the judge of for whether the publication was necessary. Now, Lord, I'll try to explain what is happening here, and we'll see how this, what we say is an error of law, comes about, and proportionate in pursuit of the available justification. And I can give another example of an important place in the judgment where this again crops up.
You say that's wrong.
Lord, there's no test of necessity at all on the publication. We don't have to satisfy any test of necessity. What's happening here, and we'll see how it comes about, is...
There may be a question of necessity which arises on the question of interference, but under 8.2.
Precisely, my lady, you have the point exactly. What is happening here, and I'm going to have to take the court to a paragraph in ZXC where we say this, the germ of this comes from, is that the test for state interference with Article 8 rights, which is under Article 8.2, is creeping in to what should be a proportionality exercise between Article 8 and Article 10.
Can we just pause?
My Lord, yes.
I was struck when looking back at Campbell at how the Article 8, Article 10 balance is, shall we say, transposed from public law and the obligations on public authorities, which those articles refer to private law in Campbell.
Yes.
And you use, like many public lawyers use, the word proportionality for everything without ever submitting where it comes from.
Yes.
And it would help me, certainly, when you make the submission that that it's what should be a proportionality exercise, as to just to unpack that.
Yes.
So that I understand precisely what you say as a matter of law, how the balance between Article 8 and Article
Yes.
10 is to be applied
Yes.
in a private law situation of this
Yes.
kind.
Lord, I'm going back to Campbell on precisely this point, because Campbell actually expressly rejects a necessary test, in a media case where Article 8 and Article 10 are in collision. I was just going to show the court another place, and there are others, but another place is at 1255. Again, the judge says it was neither necessary nor proportionate. Now, one reason, and my Lord the Master of the Rolls again, I may say so, has highlighted the point, there is a subtle difference between proportionality when you're looking at state interference and the concept and the exercise you're doing in this class of case. In this class of case, you're weighing the Article 10 right, you're weighing the Article 8 right, and you're saying what interference with those respective rights would the grant of relief represent, or the refusal of relief represent, and then you, having done that balancing exercise, you reach a conclusion.
Now, I hope you're going to repeat that submission more slowly as to precisely
Yes.
what you say we should be doing, the court should be doing, because I want to write it down and I didn't have time to
No.
do that. Or you might think one of your team might be able to do that
Yes.
for us. I think it's of central importance to this case,
Yes,
the exercise that the court is supposed to be embarked upon,
yes,
and then, of course, to test whether the judge undertook that exercise
yes,
correctly as a matter of law.
yes. Look, can I firstly deal, and I'm not ducking your...
I'm not
No,
rushing
no.
you.
I'm not ducking your Lordship's question at all, but can I just explain where we say the judge's approach comes from, just so we understand it. He refers to the case my Lord Justice Bean was in, ZXC, at paragraph 29 of his judgment. He doesn't say any more, but he alludes to the judgment. Now, we need to look at ZXC, which is an authorities bundle 2, at tab 33, and just at one paragraph. Sorry, I got the wrong. 36, I beg your pardon. It's a mistype by me. Tab 36, sorry. At paragraph 46 of Lord Justice Simon's judgment, this is where it all goes wrong with respect.
Sorry, where Lord Justice
At
Simon
46,
went
this
wrong.
is Lord Justice Simon's judgment in ZXC, which is going to the Supreme Court at the end of this month. If there is no reasonable expectation of privacy or legitimate expectation of protection, the test being synonymous, in relation to the matter of complaint, there is no interference with the personal autonomy of the individual, and Article 8.1 is not engaged. Then there's a reference to JR 38. I'll come back to that. If there is such an expectation, and this is the problem, it is for a defendant to justify the interference with the claimant's privacy at stage 2 of the inquiry. See in Re JR 38, Lord Tilson at paragraph 85. But JR 38 is a police case involving the state, and completely different principles are engaged. And I'm going to show your Lordship why we say that is so. That's at tab 33 of the same bundle, JR 38. Now you'll...
Sorry, just go a bit more slowly.
Sorry,
Mr. Caldecott. You say that paragraph 46 of ZXC,
Yes.
from which the judge got this,
Well, I think he then went back to JR 38, is my guess, is
And
what
then
happened.
went back to JR 38.
Yes.
But your submission is that this is wrong.
It is, my lord. It's wrong because it's applying state interference tests.
Is it ratio?
Well, that's a good question, but in this case, it's certainly part of the judge's ratio. His whole approach,
No, is this ratio in this case, which is now going to the Supreme Court at the end of the month, by which we are unfortunately, Mr. Caldecott, bound. We don't have discretion if it's the ratio of the case.
well, my understanding is, and I have seen skeleton arguments in the ZXC case, my understanding is that this point is, I'm not the counsel for Bloomberg, who is the respondent. At this point, I don't think is raised, but it may be because I've only seen a draft of the case. But it is a very important point for reasons I'll develop.
Before you leave this point, would you quarrel with what the way the judge puts it, having referred that authority, but what he says in paragraph 31, which is where he says how the exercise should be undertaken?
Lord, I have perfectly candid with the court. We don't have a problem with 31 of the judgment, subject to the words vice versa going in at the end of the first sentence. That's a small cavil, I accept.
So you would accept that's an accurate
Yes.
description
Yes.
of the exercise that should be engaged
Yes.
in. The criticism is it wasn't engaged in by the judge, and we look through the
Yes,
judgment.
precisely, lady, yes. He then departs from it gradually, and we then get into this question of justification, burden and necessity. Can I just go to JR 38 and develop this a little bit, because it really is important at this point. What the court will have seen, that the paragraph referred to in ZXC is paragraph 85 of In Re JR 38, and that's tab 33, page 1162 of the report, page 883 of the bundle. Lord Master World probably prefers the report page references. It's 1162 of the report.
I'm just having, yes.
62, please. I'll be jumping around a little bit to explain
Okay.
how it develops. Can I just give the court a very, very short summary? This was a judicial review case about a name and shame policy employed by the police using photographs of young rioters. No Article 10 rights were engaged at all. It was a straightforward question of justification under Article 8(2). And that has to be, the court will know, both necessary and proportionate. At the end of paragraph 85, first of all, the last sentence, having dealt with the initial threshold of the engagement of Article 8, if so, it is then up to the defendant to justify the interference with the defendant's privacy. And then we see the critical point. He praises the analysis of Lord Justice Laws in the next paragraph in another police case called Wood. And the critical part of this extract from Lord Justice Laws, just below the letter C on the following page, 1163, first, the alleged threat or assault to the individual's autonomy must, if Article 8 is to be engaged, attain a certain level of seriousness. But then this, secondly, the touchstone for Article 8(1's engagement is whether the claimant enjoys on the facts a reasonable expectation of privacy in any of the senses of privacy accepted in the cases. So that's very similar to the first stage that we have in an ordinary civil private action. Absent such expectation, there is no relevant interference with personal autonomy. But then this is the critical part, and it's really a point my Lord the Master of the Rolls has already made to me. Thirdly, the breadth of Article 8.1 may in many instances be greatly curtailed by the scope of the justifications available to the state pursuant to Article 8.2. There is no reference at all to Article 10 here for the very simple reason that the state has no Article 10 rights. And just while we're at it, if one goes, 85 immediately follows a citation from the Axel Springer case, and if you look at 52, you'll see why it's relevant as regards photos, with a view to defining the protection afforded by Article 8 against arbitrary interference by public authorities. Now, on paragraph 103, right at the end of his speech, Lord Toulson agrees with Lord Kerr on stage 2. They differed on whether stage 1 was satisfied, but he agrees with Lord Kerr, who in fact dissented on stage 1, but he agrees with Lord Kerr on stage 2. Now, what is really interesting, if you go back to Lord Kerr's judgment on stage 2, and you immediately see the heading. It starts at paragraph 67 on page 1158. The court will notice the heading immediately, justification. Justification of interference with a qualified convention right, such as Article 8, rests on 3 central propositions. The interference must be in accordance with the law. It must pursue a legitimate aim. And then, of course, this very special use of the word necessary, and this reflects the wording broadly of the Convention, and it must be necessary in a democratic society. Proportionality is a particular aspect of the last of these requirements. And I don't need to take, the court will be well aware of this, but if you go down the page to just above letter G, you'll see an exegesis on the meaning of necessary in a democratic society, and the well-known speech of Lord Reed in the Bank Mellot case is referred to in paragraph 72. Now, not only do we say this is importing state interference concepts into this civil dispute, we also say that in fact the necessity test is expressly ruled out in Campbell, which is of course a conventional civil case, not a state case. Can we, I'm sorry to jump around, but it's inevitable, I'm afraid. We could go back to Campbell at tab 18 of Authorities Bundle 1. First of all, a passage that I think my learned friends rely on, but it's right to point it out while we're here. Paragraph 51.
Lord Nichols.
Lord Hoffman in this particular case, paragraph 51. Just at the end, it focuses, it is not late, upon the protection of human autonomy and dignity, the right to control the dissemination of information about one's private life, the right to the esteem and respect of other people. It's interesting that use of the word esteem, but of course reputation is also part of Article 8 and is also engaged in this case. Now, could I ask please to go forward to 61 to 62? If one looks at 61, Lord Hoffman, who of course was in the minority on the facts of this, that brings me to what seems to be the only point of principle which arises in this case. Where the main substance of the story is conceded to have been justified, should the newspaper be held liable whenever the judge considers that it was not necessary to have published some of the personal information, or should the newspaper be allowed some margin of choice in the way it chooses to present the story? In my opinion, it would be inconsistent with the approach which has been taken by the courts in a number of landmark cases for a newspaper to be held strictly liable for exceeding what a judge considers to have been necessary. The practical exigencies of journalism demand that some latitude must be given. Editorial decisions have to be made quickly and with less information than is available to the court, which afterwards reviews the matter at leisure. And then at 68, also Lord Hoffman, this is an important point in the present case, and partly why we've given the court a blued up copy of the article, because it's very striking what passages are not complained of in the article. 68, Lord Hoffman says this: accepting that Miss Campbell has a residual area of privacy, the question is whether it was infringed by the publication in this case. To answer that question, one must assess the disclosures said to be objectionable in the light of the disclosures conceded to be legitimate. One must then ask the question whether the journalists exceeded that attitude which should to be allowed to them in presenting their story. And then Lord Hope, please, at 115. This is quite a...
So I'm just jumping ahead a little. You say that we've got this blued up copy which looks at highlights the passages complained of.
In privacy, yes.
In privacy, but then you say there are passages that are not complained of. I mean, I thought that the whole disclosure of the letter in the press was complained of.
The whole text of the letter is complained of.
Right, but not certain aspects.
But certain aspects of the letter and the toing and froing about the letter are not complained of at all. And that makes Lord Hoffman's observation quite important, and it's certainly an aspect of the balancing exercise, assuming stage one is passed. Because the question, one of the questions arises in the public interest, well, the reader would say, well, how do I know where the merits of this really lie unless I see the text of the letter? That's a question which we have to look at in a bit more detail later. And that's obviously a factual issue. 115, please. Lord Hope, we're now on, who was in the majority on the facts. The first question is whether the objective of the restriction on the Article 10 right, protection of Miss Campbell's right under Article 8 respect, is sufficiently important to justify limiting the fundamental freedom of expression which the press assert on behalf of the public. And that rather reflects the way my Lord the Lord Master to Rolls put the question to me. And we would say that that is a correct formulation.
Well, this reflects what the judge said at 31, assess the justifications for interfering with each right, and that's why the word justification crops up in different contexts. One has to be conscious of how it's used.
Ladyship is right, and indeed there are perfectly proper decisions which say justifiable in the public interest, and the word justification certainly does appear. But what we submit has actually happened here is that the JR 38 notion of justification has crept into the analysis and skewed it.
Well, the JR 38 notion of necessity.
Yes.
not justification.
Yes, necessity, your Lordship's right. It's necessity is a sub, yes,
But the word used there was justified in that paragraph.
it was.
Jail.
Your Ladyship is right, but I'm not saying, and indeed your Ladyship is also right, that a number of these cases you do see the word justified in the public interest and so on and so forth, and I'm not saying there's any magic in the use of the word justification, but it's this weighing of necessity and the concept of burden coming into it, which is, with great respect, wrong. There is a burden on the state to justify. There's no burden on us, it's just a question of balancing the rights. There's a burden, factual burden on proving the facts, and then the court does its balancing exercise. Lady Hale at 137 it should be emphasised that the reasonable expectation of privacy is a threshold test which brings the balancing exercise into play. It is not the end of the story. Once the information is identified as private in this way, the court must balance the claimant's interest in keeping the information private against the countervailing interest of the recipient in publishing it. Very often it can be expected that the countervailing rights of the recipient will prevail. And then at 140, this is a fairly astute observation, the application proportionality test is more straightforward when only one convention right is in play. This case is particularly complicated because Mr. Markle's reputational rights are engaged as well as his Article 10 rights because of the attack on his reputation, which I'll have to come to on the facts. The question then is whether the private right claimed offers sufficient justification for the degree of interference with the fundamental right. It is much less straightforward when two convention rights are in play and the proportionality of interfering with one has to be balanced against the proportionality of restricting the other. And lastly, Lord Carswell at 167 and this is another quite different use of the word necessary. The last sentence of 167, I also agree with him that in order to justify limiting the Article 10 right to freedom of expression, the restrictions imposed must be rational, fair, and not arbitrary, and they must impair the right no more than necessary. Now, that brings me, my lord, to a second area of fairly major challenge by us, with great respect to the judge's treatment of right of reply. Now,
well, can we just summarise where we've got on the first challenge?
yes,
So the first challenge is really under the heading of the judge's approach to the second stage
yes,
as a whole.
yes,
And what you submit is that he stated the test correctly at paragraph 31,
yes,
but then proceeded to apply the wrong test
yes,
and transposed a test of necessity or need for justification from public law into
yes,
private law, which was not found in Campbell, indeed was expressly rejected in Campbell.
yes,
Right. And I suppose you then go on and say if he'd applied the right test, he would have got a different answer,
yes,
or would have said it was a matter for trial, which...
yes. And yet to be appreciated that necessity in this context is a very high hurdle indeed.
It's normally strictly necessary are the words that are used in this
Yes.
context.
Yeah. Now, this brings me to the right of reply cases. As I say, there are three layers of public interest at issue in this case, of ascending, well, not quite ascending width. Firstly, the corrective principle, which one can see when one's dealing with private information might be approached on a relatively narrow basis, or could be depending on the facts. Secondly, the right to reply cases, which all emphasize the width to be given to the person who's attacked. And thirdly, the wider public interest, bearing in mind the issues and the personalities involved in this particular case.
What was the third one?
The much wider public interest simply arising from such matters as why didn't he attend the wedding? Was he behaved appallingly to his daughter? Had she shut him out after the wedding, and so on and so forth? And I'll develop these when I get to the facts. But there are conceptually three different public interests engaged here, and they need to be separated out. And the one I'm dealing with now is the second, which is the question of right of reply. And this will be very familiar to my ladyship and indeed to my Lord Justice Bean, who I know has heard at least two of these cases. But can I just quickly show the court where the foundation of this comes from? It's a case called Lawton and the Bishop of Soda and Man, which is an Authorities Bundle 2, tab, sorry, I beg your pardon, I think I've got one wrong. Authorities Bundle 1, I do apologise, tab 2. And I'll take this shortly because these principles are very well established. This was a decision of the Privy Council, and at 5 of the report, at the very bottom of page 14 of the bundle, page 538 of the report, it was to this speech, I'm going to trouble you with a rather complicated fact, that the bishop in the next assembly of his clergy and convocation thought proper to reply, and their lordships are clearly of the opinion that his charge was a privileged communication in the ordinary sense of the term, on the well-known principle that a communication made in good faith upon any subject matter in which the party communicating has an interest, or in reference to which he has, could I just ask the court to note these important words, has or honestly believes he has a duty, is privileged. It is made to a person having a corresponding interest or duty, although it contains criminatory matter, which without that privilege would be defamatory and actionable. It refers to an old case called Whiteley and Adams. Now, the important point, this is a common law privilege, not a statutory privilege. It's based on the notion that if you make a public attack, the person attacked has a right to appeal to the public, so they also know his reply. So it is based on traditional concepts of community of interest. The next case is an Irish case called Dwyer and Esmond, which is in the next tab. It's Chief Baron Palace's judgment. He was overturned on the facts, but plainly upheld on his legal approach. He was an unusual judge. He was both Solicitor General, Attorney General, and a judge for nearly 40 years, so he's a man with an unusual career. But be that as may, his judgment starts at the bottom of page 548 of the report, page 25 of the bundle. This is reflects even more clearly precisely the point I'm making. Page 550, 27 of the bundle. The court see the middle paragraph, just above it, appeals in such forms through the public press are appeals to the judgment of a tribunal which has a recognised right to form a judgment. In truth, every libel sustained as a fair criticism supposes the existence of such a right of judgment in the public. In general, no doubt, the right of criticism and judgment in the public is restricted to matters of public interest. But he who appeals to the public for their judgment upon a matter not public cannot, for the purpose of preventing his adversary's defence, be heard to say that the public have not the right to pronounce the judgment which he so asked. I'm sorry, I'm asked to read on. The right of judgment carries with it, to those in whom it is vested, an interest within the meaning of the definition in Harrison and Bush, in everything which ought to be known to ensure that judgment being just. Enough. And then at page 552, the first new paragraph, does then the defence show that the matter complained of was matter of defence or vindication of the defendant's conduct? We have been forcibly asked not to restrict the matter of defence within narrow limits. I am not disposed to do so. In fact, he concluded that the reply did go beyond what was sufficiently germane to the attack, and the Irish Court of Appeal disagreed with him. And then it is of interest to look at page 254 of the following tab, the Court of Appeal's judgment, tab 4 of the authorities bundle, page 43 of the bundle, 254 of the report. About 10 lines down, the court sees the reference to the Court of Exchequer. Then immediately after that, page 254, about 10 lines down, just above the top punch hole. But at the same time, I think a court should not overrule a plea of privilege on such a ground, unless it found itself in a position to decide without any doubt that the statements contained in the letter of the defendant had no reasonable connection with the charges brought against him, in reply to which those statements are published. And last and not least is the famous case of Adam and Ward, which is at tab 5, immediately again the next tab, decision of the House of Lords in 1917. Lord Atkinson deals with the width of the language to be allowed at page 339, page 85 of the bundle. About 7 lines down, the court will see a reference to Lawton and the Bishop of Soda and Man, and then there's a citation from Lord Halsbury. But suppose it was not true, suppose it was not accurate in the sense in which people would have understood it, suppose the person who wrote that document intended to tell the truth and believed in the truth in what they were writing, even though in the mind of some other person it should be inaccurate in form. It seems to me that it would be impossible to contend that that would be evidence of malice, and of course malice defeats the privilege. These authorities, in my view, clearly establish that a person making a communication on a privileged occasion is not restricted to the use of such language merely as is reasonably necessary to protect the interest of the discharge or duty. The court will notice that the word reference necessary, which is the foundation of his privilege, but on the contrary, he will be protected even though his language be violent or excessively strong, if having regard to all the circumstances of the case, he might have honestly and on reasonable grounds believed that what he wrote or said was true and necessary for the purpose of his vindication, though in fact it was not so. So that's dealing with the width of the language. And I don't think I need trouble the court about no one suggesting here that the worldwide coverage of people article affects the question of audience. We're not here concerned with the width of the audience. Now, the Lordsman Lady, the novel issue which this case raises is not an entirely easy one, is how does this right of reply factor in to a case where the attack is at least in part related to a document which is said to be private and which the reply deploys. There are, at first sight at least, two possible answers to that question. One is that you simply apply the full width of Lord Atkinson's approach. But the second is, and I think I would accept this is probably the more modern approach, that you still do the conventional stage 1, stage 2 exercise, but if you get to stage 2, this is plainly a particularly strong Article 10 right, not least because it engages the attacked party's Article 8 right to reputation. It is also absolutely clear that there is no question of the attacker's consent being required in order to make the reply. Now, we do, with great respect to the judge, take serious issue with his approach to this important legal issue in the case.
Now, I'm not sure that's how it's been put before, and it would help me if that were reduced to writing.
It is. Thank you very much. Well, just so you have a rush, I think it's ground 5.
I know it's ground 5.
Yes.
But,
So,
the way you just formulated it,
yes,
with the stage 1 and stage 2 and the attacker and the attacked.
Yes.
It's quite useful
Yes.
to have it formulated
Yes.
in that way.
Can I just say this? The fact of the attack may be material at stage 1 as diminishing the Article 8 right, depending on the facts.
Well, I thought you just told me that the article stage 1 right was binary and diminishment didn't matter. The answer was yes or no.
Yeah.
There is a right.
Yeah.
And then you consider at stage 2 whether that right is diminished by the right, the fact that
Yes.
it is a reply. I mean, which is it? Mr. Cooper?
I think it's a fair question, and the point on ambivalence, which I'm going to come to, which is another legal principle in this case from a decision of this court in AAA. In that case, it arose at stage 2, and I'm content to put this on stage 2.
But consent can arise. I mean, it's not an easy.
It's not an easy point.
This is not an easy
No.
point that can be reduced to a few simple
No.
propositions, because consent arises at stage 1.
Yes, and if one looks at the Murray factors, one can certainly imagine a case where if a party said, you've only got to look at this document to understand what a liar the defendant is. I'm taking a really fairly silly example, but you see the point. And the defendant then replies and is sued on his reply for deploying the very document. One can see on those facts the court might well say, well, there's no reasonable expectation of privacy. You've actually been inviting him to do it. But the factual spectrum, this is why the courts say an intense focus on the facts is so important. But can I just deal at the moment with how the judge deals with this as a matter of legal principle? And the main problem,
I mean, I'm sorry to bang on about this, but that is quite significant, because I think we need to know whether you do say that in this case there was no reasonable expectation. The judge ought to have held there was no reasonable expectation of privacy, because the letter is akin to the allegation you just suggested, in that, knowing what they know about Mr. Markle and knowing about how the letter was prepared, obviously one would expect a response. One would
Yes.
expect the defendant to be
Yes.
the defendant, Mr. Markle, to be
Yes.
upset. I mean,
yes,
is that what you said?
yes, look, we put it that way, and we also put it at stage 2 if we get there.
Okay. It's quite a nuanced issue, isn't it?
It is, my lord, it's not easy.
Has there ever been a case of summary judgment given on a primacy claim before?
Yes,
There has.
the Prince of Wales case involving his journals, and there's one other, I think, Mr. Justice Nicol, which the judge refers to actually in his judgment, is a blackmail case and doesn't really assist us, I don't think, or a near blackmail case, I should say.
Yeah.
No, it was an argument. And Murray, I should say, was different. That was where the defendants applied to strike out the case and failed. Prince of Wales is the case where summary judgment was given. But there was none of these complications of reply to attack in the Prince of Wales case. And the Prince of Wales case had this additional feature, that the journals were sent out marked strictly private and confidential. And the judge found that they found their way to the newspaper through an employee who was in breach of confidence in giving them the journals, and the Court of Appeal attached a fair amount of weight to that fact.
You say that it would be analogous if the courier entrusted with the letter, instead of taking it to Mr. Markle, taken it to your clients, would then published it.
Yes. Yes, before any of this happened, there'd then be very interesting questions in equity about as to whether we would be bound by the privacy of the letter if it was simply. This is before the attack and anything else happened on your lordship's hypothesis. And one can well see that there would be arguments, quite strong arguments in equity, that we would be bound by the evident confidentiality, subject only to being able to run a countervailing public interest case. But one can see that the court didn't find that appealing in the Prince of Wales case. That was a summary judgment case. Now, the most important, there's quite an important issue on the pleadings as to whether or not we were contending that the attack was objectively false. And I'll have to come to that in due course. But he dismisses really almost all the reply to attack case at paragraph 112 of his judgment. And I should just mention that he has mentioned reply to attack and self-defense at 109. So this is an introductory paragraph at 109, but I should in fairness just point that out. And then at 111, he says we don't accept this proposition, but be that as it may, he says in the middle of 111, having referred to various matters that we relied on, clearly the defendant has not adopted Mr. Markle's account. It's not the defendant's case that this aspect of the People's article was false. But the critical legal approach which goes wrong is in 112. This aspect of the defence is, in my judgment, entirely hopeless if a published article gives a one-sided account of a relationship and that account is false or misleading and damaging to a person, that might provide some justification for him seeking to publish a proportionate reply in self-defence to the same audience. And then this, but there is no authority to support the view that the mere fact that a person believes his portrayal is untrue is enough to justify a reply. That cannot be the law. It would legitimise replies which were in fact false and unwarranted, as might well be the position here on the defendant's case. Now, we say, actually, if you look on the wedding allegation of the texts, it was plainly false on the material before him. If you look at the fact also about the continuing or absence of any communications between the claimant and Mr. Markle after the wedding, an allegation against lying against him was also untrue, but that is not the real point. He is fully entitled to reply if he honestly believes that the attack is false. Objective falsity of the reply is not a disqualifying factor. Knowledge of its falsity is. I might add, so might recklessness be, in the sense of not caring whether what he says is true or false, which is the other heading of malice, but that's a refinement. Thirdly, on the facts, as we'll see, the People article makes allegations against him which we submit are objectively false, and that brings into play additionally the corrective public interest. But even if we're wrong about that, there was ample material for Mr. Markle to take the view that he was being produced, and for it to be open to him to give his reply. And I will have to develop this, but again, if one goes on as to how you may remember there's an important point about the letter not being an olive branch. That was the true position. The People article presented it as an olive branch.
Before we leave that, can we just go back to the sentence that you criticise as no authority to support the view that the mere fact that a person believes his portrayal is untrue is enough to justify a reply? Do we attach importance here to the use of the word mere? I mean, what we're talking about is not I think one has to read all this in context, but is that wrong?
But we would respectfully submit, looking at Sader and Mann, yes, it is wrong.
Do you also say that the last sentence of that paragraph is wrong?
Yes, I do, for the same reason that I was given developing earlier.
You were saying it's the wrong question
Yes.
anyway.
Yes, but it's the wrong question anyway. But what is important to appreciate is qualified privilege is an offence based on policy. And it therefore must follow that the width to the reply given to the person who's attacked is a policy-based privilege. And it therefore does have to be given, we say, strong weight at stage 2. And we've discussed already, I've already made the separate point about stage 1, and I'll come to the last point on this, which is about ambivalence. Now, can I just mention very briefly McKennitt and the zonal argument? In this court, because there's an awful lot to go through, I am not relying at all in this court on any disclosures to the authors of the book or possible disclosures to the author of the book about matters other than those relating to Mr. Markle and her relationship with her father. There's quite a lot in the pleadings about it. It doesn't really feature in the grounds of appeal, but it is, I accept the zonal argument in any event, that by disclosing matters relating to other private material does not per se deprive you of a right of privacy in a discrete matter, even if it's in the same broad zone. Now, my lord, the last legal point, and this is what I call ambivalence, because it's a phrase that the Court of Appeal used in a case called AAA against Associated Newspapers, which was strongly relied on by my colleague below. It's a decision, first of all, of Mrs. Justice Nicola Davis, as she then was, at Authorities Bundle 2, tab 30. Can I just give your lordships a very brief resume of the facts? AAA was a child born in 2009 and the daughter of an unmarried woman, and the father was a prominent elected politician. And there were articles published in the Daily Mail about the child's paternity, and a photograph of the claimant in a buggy pushed by her mother. The judge did award damages for the use of the photograph, but rejected the claim in privacy in relation to information about the paternity, and confined the injunction to the photograph. In fact, I think undertakings were given. Now, the interesting aspect of this case is its analysis, and in fact, in this case, it's at stage 2, but it was plainly looked at stage 1 as well. The first instance judgment at tab 30. Could I just please take the court just to explain the factual background? The first aspect of ambivalent conduct relied on by the defendant media was a country weekend party, which is dealt with at paragraph 97. And the conversations were in a private annex, but there was plenty of discussion between the mother and this gentleman, in fact I think Mr. Coleridge, about paternity. So she was happy to talk to it and imply, I think at least who it was. And then secondly was a magazine interview dealt with at 98 and 99. And you'll see that the interview she gave to the magazine, 98 second sentence, contained reference to the claimant and speculation as to her paternity. And then you'll see that there's said to be a common thread between the two. My sense of the account with the conversations which each had with the claimant's mother is that even with people she hadn't previously met, she was not averse to hinting at or speculation as to the identity of the father of her child. And the Court of Appeal, so I should just, and what she decided was that she essentially decided that there was a reasonable expectation of privacy, but that it had been compromised by these two aspects of her conduct, and that therefore she failed at stage 2. And we see that at paragraphs 116 of her judgment. She uses the words, in my view, the result has been to compromise the claimant's reasonable expectation of privacy upon the issue of her paternity. I don't find that the claimant had no reasonable expectation of privacy. Rather, the weight to be attached is of a lesser degree than would have been the case had nothing been said or permitted to be said upon the matter. And then at 119, and it's really the same thing, can I just pick up a point that my ladyship put to me as an example of the word justified being used in this context, about 4 lines up at the end of a sentence. I find that the publication of the fact of the claimant's birth and the circumstances alleged was justified. So it's quite right that the complaint we make really is about the use of the word necessary rather than the word justification and justified. Court of Appeal in the following tab, and it deals with the judge's finding at paragraph 3. Don't really need to repeat that. Paragraph 21 refers to the Murray factor, any relevant conduct. And then at 25, this is where the Court of Appeal used this word ambivalent. In my view, the judge was right to regard the mother's behaviour at the weekend party as indicative of an ambivalent approach to the confidentiality of the claimant's paternity. Then they developed the reasoning for that. And then at 37, the judge made a careful and nuanced assessment, and we say that really is rather missing in this case. The judge made a careful and nuanced assessment of the mother's attitude at paragraphs 25 to 29. The evidence amply justified her conclusion that the mother's conduct demonstrated at the least an ambivalence towards and an inconsistent approach with her stated aim in these proceedings. That case was strongly relied on by my predecessor before the judge, but it doesn't appear anywhere in the judgment. We say it is an important principle and does have weight in this case. That's the law, my lord.
I mean, you refer to it as ambivalence, which I must say I'd rather understood you to be saying that the matters concerned with which the letter dealt was out in the public domain.
Yes, certainly the broad subject matter of the letter was out there. We do say that, yes, informationally.
Yes. So, but I mean, ambivalence to the confidentiality of the letter is a slightly different point.
Yes.
Particularly for the detail of the
letter. There are two different points subtly in play here. The Lord is right to distinguish between them.
Yeah.
Well, before you move on, can
Yeah.
I just ask you to go back to this, the way in which reply to attack, which is a concept that arises in qualified privilege and defamation,
Yes.
how that maps on to claim for misuse of private information
Yes.
as a matter of law.
Yes. Well, I made the submission, which I hope is correct, that it wouldn't be right simply to apply the full width of Lord Atkinson's scope in Adam and Ward, because where the claim is brought in privacy, I can envisage a case where the material might be acutely private. It did come within the reply to attack, but the court would say this can't be right that the reply had to go this far. In other words, we don't advocate the full width of Lord Atkinson being applied willy-nilly in a privacy case, so that's not our position. We accept that the two-stage conventional test in privacy should still be applied. At stage one, we say it's relevant to consider all the facts surrounding the attack as relevant conduct, going to whether there is a reasonable expectation of privacy. If we're wrong about that, we say that the reply to attack is a very strong Article 10 right and would need a very strong Article 8 right to trump it. And that's looking at it at the weighing stage, at stage 2.
Does it make a difference if one's dealing with private information or allegations which may or may not be defamatory?
I will seek to persuade the court that these allegations were plainly defamatory.
So which allegations?
Well, there are 3
In the People article.
in the People article, yes, which is the trigger for the whole.
Yeah.
It's the trigger for, is undoubtedly the trigger for the articles. We do say that the allegations in the People article are defamatory.
Pleaded? Is that pleaded?
No, I don't think the word defamatory expressly said in the pleading, but the concept of reply to attack was plainly raised before the judge, and that's no doubt why he deals with it. Of course, one of the reasons that I'm accepting that the qualified privilege in a defamation case shouldn't simply be imported en bloc into privacy without more, because I think it would pose problems if one took that approach.
Because in a defamation case, the claimant's case doesn't get off the ground unless they can establish that defamatory allegations are made of them. And it's only in that context
Yes.
that one has to then reach for the potential defences, which might include
Yes.
reply to attack.
Yes.
But that wouldn't be the case in a privacy claim.
No, it wouldn't in a narrow sense. But if you're looking at the weight of the Article 10 right and the weight of the Article 8 right, the fact of the attack may be highly relevant. And we say it is highly relevant. Now, to assist the court, and it's not easy to give some structure to these facts, I'm going to approach them by reference to 6 acts, if I could use a theatrical terminology. Firstly,
You're going to approach the facts.
the facts next.
Why are you making submissions about the facts?
Because there are criticisms in the grounds of appeal about the judge's approach to the facts and how they fit in. And this requires an intense focus on the facts. And we say the judge in key areas didn't, but also in fairness to him, there is additional material which was not before him, which is also material, and that's part of the materiality aspect.
I find this very difficult on an appeal against an application for summary judgment. I mean, all you presumably wish to establish is that you had shown a reasonable prospect of successfully defending the claim.
Yes.
And therefore, the judge's approach to the facts is neither here nor there, if you're right, that on the facts there were triable issues. So
Yes.
the normal approach to this type of appeal, in normal cases, and I freely accept this is not a normal case, is for the defendant to say, we shared a triable issue on the following issues. And I can't see why that isn't an appropriate thing for you to say here. because the very unfocused treatment of the facts and all the very complicated and nuanced circumstances of the chronology you took us to earlier doesn't really get to the nitty-gritty. The nitty-gritty is, was there a triable issue on anything that the judge should have identified in order to deprive the claimant of summary judgment? Yes or no?
Yes.
Sorry to be binary. And it would help me, certainly, if you could identify what he got wrong and where there was a triable issue that should have been the subject of a trial, not of a summary judgment. I mean, that's the bottom line, is it not?
No, with respect, I don't disagree at all with that, and it's not for me here to persuade the court that we're right.
No, you may well, you don't need to, and that you
No,
don't need to go
no,
that far.
no, I don't.
So
need to go that
what
far.
do we do about that? I mean, I've been very bemused by all the additional evidence that's come in. I mean, a 23-page statement, I think, from the claimant herself. No such evidence before the judge below. What are we supposed to do with that? I mean, all we can do is look at it and say, well, there we are. There's a 23-page statement, not cross-examined. I mean, what are we... All we're doing here is working out whether the judge was right or wrong in giving summary judgment.
Yes, but my lord, I think it is necessary for me to at least highlight where we say triable issues truly arose.
Yes,
and
please
where
do.
where the judge did not confront them as he should have done.
Could you put them like
Yes,
that?
yes, my lord, I am going to put them like that.
Excellent.
Because, my lord, I do fully understand the point your lordship puts.
I mean, we have been deluged
Yes,
with material.
yes,
Absolutely deluged with material.
Yes.
In a situation which is really quite simple. And the satellite issues that the parties have been pleased to exchange blows, I can put it figuratively, about, don't help us decide the core questions in the appeal. And I am absolutely very, very keen to be addressed on the core questions and not all the satellite issues of fact.
yes. Well, look, can I keep to my 6 acts, but bear in mind, because otherwise it is a difficult case.
Sounds so theatrical, though.
But
6 acts. What about 6
My
submissions?
presentation will be prosaic, I promise. It's just a convenient way of chapters, I should say, in a more
I don't
straight
want
way.
chapters.
No.
I'm not being rude, Mr.
No.
Caldecott. I want submissions
Yes,
about what the judge got
Yes.
wrong on the facts and what the tribal issues were that he
Yes.
should have held.
yes.
Full stop.
Heading 1,
Heading 1.
Lord, run up to the wedding.
Well, okay. It's an unpromising heading in the light of what I've just put to you. Yep. I've written it down, Mr. Caldecott.
Preparation of the letter.
Well, is that heading 2?
That's heading 2.
Right. You're just giving us the 6.
Yes.
Yeah.
Thirdly, the reply, by which I mean Mr. Markle's reply. Fourthly, cooperation with the authors. Fifthly, the People article. And sixthly, our articles. And Lord, I will, over the adjournment, consider if I can, in the light of the invitation, whether I can shorten his. But I.
Well,
Let's
I
see
mean,
how we
it's
go.
not helpful. I mean, just to be blunt about it, it's not helpful to be told that there was an exchange of material in the run-up to the wedding, some of us probably looked at some of it, which meant there was, as the judge, I think, described it, I can't remember the precise word he used anyway, the judge said there
Fractious.
was unhappiness, fractious, the atmosphere was fractious. Good. I mean, that was what he said. Was he right or wrong? Is the question I'm concerned about.
Well, let us take that, if I may, just as an example
Right.
of the run-up to the wedding and why it matters.
Yeah.
It's slightly, it's going out of order. I'll just have to take a minute to find where the relevant section is. People article. I think it's important, perhaps, at the start, in the light of your lordship's invitation. Yes, the people.
We've got what he said about the people article at the beginning.
Yes, it's in Core Bundle 2 at page 373. And why I start with this, because this is critically the attack. So this is an important point before the judge, both in terms of the law and in terms of his approach to the facts. So, page 373 is where it starts, and tab 21.
This is the article itself.
Yes, in the People magazine. It starts on page 373, and it's the front page lead. And what we need to do, if you please, is go to page 377. Now, can I just draw the court's attention to the orange square just to the right of the mirror splash? Does the court see it? There's a sort of, it may not be orange actually, it's more sort of beige. At page 377.
Yellow ochre.
Yellow ochre, I accept that. It's headed Painful Mistruths, and it says this. While the second half of it, while her dad, Thomas Markle, has said, she shut him out, claims her friends say are patently false. And then to the right-hand side of that little standfast, the second paragraph, there's a reference to Prince Harry and then to the claimant as an uncaring daughter. Meg has silently sat back and endured the lies and untruths.
Sorry, I can't see that.
Second paragraph, Lord, about 7 lines down, you'll see the reference to an uncaring daughter. She's been portrayed.
Yes, thank you. Yeah.
Meg has silently sat back and endured the lies and untruths. That's about uncaring daughter, and we say that those two plainly would be read within seconds of each other, and Mr. Markle was fully entitled to take that as being an allegation that he lied about that matter. And then you'll see a reference to setting the record straight and her carrying, and then we go on page 378 to the run-up to the wedding. And I've already explained in my neutral summary about the paparazzi photographs and so on. And then it reads, and this is important, it reads about 8 lines down. The next day, the pictures came out. Even with all that, Meg and Harry were still so focused on getting him to London. At no point was there talk of, now that we know he lied, he's in trouble. And then this, Tom wouldn't take her calls, wouldn't take Harry calls. The next morning when the car got there to take him to the airport, he wouldn't get in. Brackets later, so it doesn't suggest she heard it from her father, Meg heard he had a heart attack, and she's calling and texting even up to the night before the wedding. It was like, please pick up, I love you and I'm scared. It was endless. And we say the clear import of that is that he was ignoring her. After the wedding, she wrote him a letter. And then we get, immediately after this, the reference to the olive branch. Dad, I'm so heartbroken. I love you. I have one father. Please stop victimizing me through the media so we can repair our relationship. Just note that appears in quotes, albeit preceded by the word she's like. Then there's the next reference, almost immediately. He writes her a really long letter in return, and he closes it by requesting a photo op with her, and she feels that's the opposite of what I'm saying. I'm telling you I don't want to communicate through the media, and you're asking me to communicate through the media. Did you hear anything I said? It was like ships in the night.
Well, the judge held, didn't he, that there was an entitlement to respond to the allegation of victimisation.
Yes, and to olive branch.
And to olive.
Yes, but what he does not deal with is the very hurtful allegation that on the eve of his daughter's wedding, he's simply ignoring her. And when one looks at it, it doesn't look as though he has even told her himself that he's unwell. Now, this is why the texts do matter.
Well, they matter if you can point something in the judgment that is inaccurate.
Well, yes. Can I take your lordship to the judgment's selection of the texts?
Well, he's not obliged to set everything out he sets it out in incredible detail. You say not enough.
No, not enough, because these at the judgment at paragraph 40 he sets out a number of texts. He says in 7 correctly that Mr. Markle gave details of his health to a website called TMZ, but the texts in which he tells his daughter that he's unwell and all the affectionate texts from him up to the wedding are all ignored in the judge's summary. They're critical to understanding why Mr. Markle felt that the suggestion that he'd been ignoring his daughter and not told her why he was unable to come to the wedding and so forth is central to the story. And I don't want to trespass on my Lord's injunction, which I understand the spirit of it, but if one looks at the texts, there are many texts from Mr. Markle they are all affectionate until a text which we can see where it all goes wrong. But he tells her time and again about
Just don't give us page reference.
Sorry, I do beg your pardon, my lady. Tab 26.
In
Tab 26 it is, of Core Bundle 2, at page 6. They start at page 639. There was abundant contact and run-up in the wedding.
639.
639 is where they start.
It's a schedule of the text.
Yes. And I'm not going to go through them all, it would be disproportionate, but to just give you an example and a flavour, he's obviously under pressure from the media. One sees that on the 9th of May at 10:18 at the top of 641. I have paparazzi in the house next door and in the house 2 houses down the street. Bearing in mind he's got some heart problems at this stage. 11th of May, I know your hard work to make me look good. Thank you, I'm getting excited. It's all so close now and I can't wait to walk you down the aisle.
So which page?
641, Lord, I'm sorry. I think it's my fault I didn't say.
Yeah.
At 10:05. Then we get the apology at 17:56 about the paparazzi photographs. The apology is accepted by Prince Harry at 1831. There is a complaint by the claimant at 1710. But one one has to bear in mind that the times here are complicated. These are all London times, and of course he's in America. I've not been reaching out to you all weekend. They were not taking any of our calls or replying to any texts. Actually, he's just replied and said, I'm back in the hospital and need an angiogram. And then in the middle of the page, I'm in the hospital tomorrow in an angiogram, and I guess I'll be there a few days. I'm okay, sorry about this, love you guys. Love you guys. Then again, they're going to put some stents in, information about anything. Then at the bottom of the page, I'm safe in a hospital in the United States. I'm going to be there at least 3 to 4 days. I'll keep you posted. Love you, and so on. And then it's true that the claimant is trying to help with the surgery. And then on the 16th of May, middle of the page at 21:56, surgery went okay. Heart attack did some damage. They went inside some stents. The doctor will not allow me to fly. So, of course, I'm sorry, but I can't come. Love you and wish you the best of everything. This is a completely different picture to the picture presented by the People article. Never called, never texted, just ignored her. And then at 03:24, who will be giving you away? If you really need me, I will come. I'm sorry about all this. And then there is a text which I am not going to read. And he's just had a heart procedure. And then there is a text in quite strong terms from Prince Harry.
Which page?
Very bottom of page 643, the last text on 643. I'm not going to read this. And
it says claimant, but it doesn't seem
it
to
isn't.
be claimant.
It isn't claimant, it's Prince Harry.
Yes.
Yes.
Can you read on top of page 644?
Yeah, I'll read it all if people want me to.
Just the top of 644.
No. Perhaps the court could just read it. And it's obvious that Mr. Markle was upset by that text. This is not a matter on which one can form any views at the moment. But he's on his own in hospital, having had a heart procedure.
And the question I have is which parts of the judge's decision making are wrong in the light
Yes.
of the materials you're showing us?
Well, it's firstly the selection of texts, bearing in mind the attack on him in the People magazine.
Yes, but I mean, just so you know where we're going, Mr. Caldecott, coming up towards lunch and you're going to have time to think about it. I understand you say the texts are partial, but that must have a bearing on a decision-making part of the judgment. Not just, I mean, judges very often are, in this case, obviously faced with a massive amount of material and put in some of it, attempting to summarize the case, and can't possibly put in everything. But you are entitled, if you do, to say this decision-making paragraph is obviously wrong.
Yes.
Based upon what you've just shown us.
Yes. Can I just take you to 111 and 112 of the judgment?
Yeah.
Having pointed out that the selection of texts doesn't address at all Mr. Markle's lengthy responses, affectionate responses. And what the judge says is this. At 112, and you'll see that 111 is dealing with acting unreasonably and unlovingly from the week before the wedding up to the date of that article. Clearly the defendant has not adopted Mr. Markle's account. It's not the defendant's case that this aspect of the People's article was false. Well, actually, look at the text. It's demonstrably false. He was in contact with his daughter in this period. And until the very end, when that email about which one might have views was sent, it was affectionate and apologetic for the one incident which was unfortunate about the paparazzi photographs. But then at 112 he says, this aspect of the defence is in my judgment entirely hopeless. First sentence of 112, and this is where this entirely coincides with our complaints about the legal approach to reply to attack. And at this stage, all I have to say is that we had an arguable case at the least that the portrayal of the pre-wedding contact between father and daughter was arguably at least a travesty of what actually occurred, and to Mr. Markle's discredit, because to cold shoulder your own daughter in the run-up to her wedding is a pretty extreme thing to be accused of. Those texts don't feature in the judgment at all, and yet the judge says this aspect of the defence is, in my judgment, entirely hopeless. And that coincides with a far too narrow view of the legal principles governing reply to attack. Then at 113...
So what you really say is that the factual questions were looked at in too singular a way, and at least demonstrated issues that could only really be evaluated as to who was right about these exchanges, which is very difficult for a court just reading them blind.
Yes, Lord, I respectfully agree.
Of evidence as to who was right and whether the response to the so-called attack was justified as opposed to necessary or not.
Yes.
And that this would be a classic case of a tribal issue in a very complex factual situation.
Yes, yes.
So that's really
yes.
what you said.
Lord, that is right. I think I also say this, that factual approach may well have been conditioned by the erroneous legal approach.
Well, you just said that.
In paragraph, it's precisely in paragraph, yes.
Yeah.
Lord, I will try and take your Lordship's injunction to heart And perhaps,
It's not an injunction, Mr. Caldecott.
no, no, but I don't mean that in
To make sure
disrespect.
that we understand fully
Yes,
the depths and reaches of your case, and that we don't get taken down
yes,
highways and byways which don't really advance either side's case any further.
yes.
But I think we've got that, and probably it may be a good time to break now.
Yes, thank you.
We'll resume at 2 o'clock.
Do we not?
No, we won't, of course. We
So
might
the advantage of that, Lord, it gives me a bit of time to get my secretars
have
out.
a little bit more time to
Yes.
think about it. That's helpful. We'll resume at 10:30 tomorrow, when we will thereafter sit normal court days.
Court rise. Just going to stop the live stream. There's a 90-second delay, so